Hello everyone. In this presentation, we will focus on the scope and importance of law of evidence. Human activity in any society falls under three heads: things that have to be done, things that should not be done, and things which may or may not be done. Law specifies the activities which should be done and which should not be done and prescribes the manner in which acts should or could be done with an intent to ensure maximum good to the maximum number of people and least harm to the least number of people. Law also provides for consequences for doing an act which is prohibited, not doing an act which is commanded, and not following the manner prescribed for doing an act when it is prescribed by law. All this is provided by the substantive law, and the manner in which the consequences have to be enforced is provided by the procedural law. We have seen that the Civil Procedure Code provides the procedure that has to be followed and the forum that has to be approached for violation of provisions of substantive civil law. Similarly, Criminal Procedure Code provides the procedure to be followed and the forum to be approached in the case of matters pertaining to substantive criminal law. Having approached the appropriate forum, a number of questions may arise for the purpose of proving one's case, like who has to prove the case, the plaintiff or the defendant? Who can be called as witnesses? What can they be asked and how? What documents can be produced before the court and how can their genuineness be tested? Can copies of documents be relied upon, etc.? Law of evidence is the law of procedure which provides answers to all the above questions and which has to be followed by the courts. Law of evidence is important because this is the law that would show how the evidence has to be placed before the court to show the existence or non-existence of facts. If there are no rules of evidence, there would be undue delay in deciding any case and justice would become a mockery. If the admissibility of evidence is left completely to the discretion of the judge, there would be lack of uniformity, uncertainty, and undue delay in delivering justice. Therefore, there has to be well laid out rules of evidence which are not fussy, and at the same time too much discretion is not given to judges. In India, the Indian Evidence Act contains the rules regarding adducing of evidence both in civil and criminal cases. But there are certain rules which are applicable only to civil cases, like rules pertaining to estoppel, and there are certain rules which are applicable exclusively to criminal cases, like provisions pertaining to confession. The basis on which rules of evidence are framed rests on two important principles. The first principle is that no facts other than those having some connection with the controversy should be looked into by the court. This is because the court should not waste its time in examining any material which has no connection whatsoever with the controversy. The second principle is that all the facts which help the court to come to a conclusion upon the existence or non-existence of the matter in issue are admissible in evidence unless it is excluded by a specific rule. For example, confession made by client to his advocate is excluded under section 126 of the Act. The law of evidence consists of two parts. The first part contains rules that determine the probative force of evidence, that is, the effect of evidence when produced. The second part consists of rules that determine the manner in which and the conditions under which evidence should be produced, that is, the manner in which evidence has to be produced. The law lays down inflexible rules excluding judicial discretion in matters pertaining to probative force of evidence, that is, weighing of evidence or effect of evidence when adduced. The rules pertaining to weighing of evidence consist of 5 classes. 1. Conclusive proof, which raises conclusive presumption, like section 112, where birth of a child during marriage, when proved, is the conclusive proof of legitimacy of the child. presumptive proof which raises a rebuttable presumption. For example, dowry death section 113b provides presumption pertaining to dowry death. Insufficient evidence wherein no presumption is raised and it does not amount to proof. Exclusive evidence, that is only evidence admissible in the matter. For example, when there is a contract in writing, it has to be proved by the document itself under section 91 of the Indian Evidence Act, and no evidence, that is devoid of any evidentiary value. For example, section 24 says that confession to a police officer is no evidence. The second part of law of evidence consists of rules regulating the manner in which the evidence has to be adduced. It does not deal with the effect of the evidence when adduced. The idea of best evidence is implicit in the Act, and this is important for effective and efficient delivery of justice. No doubt the subject is highly technical, but proficiency in this law is important because whether the proceedings are civil or criminal, unless proper evidence is adduced in a proper manner, the case in hand cannot be proved. And without proving the case in hand, one cannot help the client to enforce or defend his right or prove the guilt or innocence of the accused. Thank you.